So what is your favorite movie?
Something About Mary might be my favorite comedy of all time.
Wow.
I love the Farrelly brothers. I love that they're from Cumberland, Rhode Island. I love that so many of their movies they make sure they get their family and friends involved, and they film on location.
Did they do Me, Myself, and Irene?
They sure did.
Interesting.
Heartbreak Kid.
I don't know
Peter
that one.
Farrelly won Best Picture for The Green Book. Bobby wasn't involved with that one, but Peter did that. That was Viggo Mortensen. That was tremendous.
Do you know those guys?
I don't. Other lawyers I know them because they
Gotcha.
grew up in Cumberland.
Gotcha.
Tight knit town.
Well, speaking of how we met, John La Rochelle, who's in your office, introduced me to you, so we want to thank John for that connection.
For sure. Another Cumberland guy.
Another Cumberland guy, that's right. I think John said to me that he had the smallest single-family house in Cumberland growing up as a kid. But yeah, anyways, thank you, John, for being here. And what I wanted you to do, and I'm a visual guy, is give us a timeline from when you graduated high school until today.
Okay.
Where you've been.
Sure.
What's been your path?
So I graduated Cranston High School East, also known as East for Rhode Islanders, in 1986. I went to the University of Rhode Island.
Okay.
I applied to two schools, Northeastern and URI. I took one trip to Boston for Northeastern and hated it. Hated the city, hated everything about it. Spent 4 years at Kingston, loved it. Had a unbelievable experience. Joined the debate team at URI, and that had profound consequences down the road in terms of the ability to orally advocate, to think on your feet, and to make a pitch that was persuasive. Upon graduating college, I took 2 years off, worked as a paralegal in this building, the Turk's Head place, from 1990 to 92 for Flanders and Medeiros. They were a business litigation, top flight attorneys, Matt Medeiros, Bob Flanders, Jeff Scheck, really, really good attorneys, learned a lot. Applied to law school, and just before law school started, traveled through Europe, got that travel bite out of the way. And in law school, you really don't know what type of law you want to do. People talk in general terms, I'd like to do litigation, really not knowing what it was. It wasn't until third year of law school that I discovered criminal. The summer going into third year, I accepted a position as a law clerk with David Cicilline. And David, very prominent at the time, criminal defense attorney, very busy, needed help writing motions, memos, etc. And as an English major at URI, I discovered that criminal law is all about short stories, right? They are all these short stories in terms of the decisions that get published or trials that get heard before a jury. So I learned to love criminal law right away, learned from David, saw his father Jack and his brother Johnny at work every day. And then I was fortunate to get hired as a Rule 9 student attorney by the Public Defender's Office.
Here in Rhode Island.
Here in Rhode Island. And I did that my entire third year of law school. And at the end of the year, I tried about 10 cases as a student attorney.
Wow. And what year was this?
This was would have been 1994 and 95.
Gotcha.
And one of my supervisors was Mary McElroy, who's now a federal district court judge. So I was fortunate after I passed the bar to get hired by the Public Defender's Office in 1995. I was with them for 6 years, learned a ton from some of the best trial lawyers in the business. And at around that 6-year mark, I was ready to go out into private practice. John La Rochelle was instrumental in convincing me you've got what it takes in private practice, because it's not about just being a good lawyer. You've got to be a good salesman. You've got to be able to bring in the business, convince a client or a client's family to hire you, and then follow up and get the job done. So I've been doing that since September of 2001. And it has been 24 years of doing it, and I love it.
Wow.
So that's the full gamut of basically a 30-year legal career.
Wow.
At 30 years, lots of people start thinking about retirement. I'm just warming up.
You're rolling up
So
your sleeves.
I'm just,
Wow.
I love what I do. I get up every day, enjoy it immensely. I look forward to the challenges of
Yeah.
working the cases I have, or getting other cases. And at the end of the day, it's about helping people. I remember I had to write an essay to get into law school. And why did I want to do it? It's about helping people. You know, Judge McConnell, who's the chief judge of the U.S. District Court, has a great saying, nobody should be judged by one bad day. And so many of our clients in criminal court will have a bad situation, a bad run, a bad day. And I'm in the business of not judging. I'm in the business of helping.
Well, that was my next question, actually, is people that see a defense attorney get hired for a case that's very salacious will oftentimes say, how could you represent this person, right? How could you defend this monster, right? So what's your response to those types of comments from people?
And I get them all the time, right?
Like you're the big bad wolf, essentially.
That's right. And there's always this assumption that if someone hired a defense attorney, that person must be guilty, and how could the defense attorney do it? Well, I consider my position almost like a priest-penitent situation, where I am representing a person against all of the resources of the state or the federal government. I am not here to judge that person. I am not dealing with moral guilt. I deal with their legal guilt. And I do the best I can to help them. The state of Rhode Island will be represented by, the resources of the police department, prosecutors, and all sorts of assistant administrative personnel. They've got that. That one defendant has me. And I'm happy to do it. Also, I'll remind people, let's not be too quick to judge. Simply because someone was arrested and charged doesn't mean they're actually guilty under the law. Proof beyond a reasonable doubt is a high standard. It's a high standard for a reason. We don't want to convict or incarcerate individuals on a low standard of guilt. It is going to be to such a moral certainty that that person should be subject to, whether it's a sentencing, probation, suspended sentence, or incarceration. All right. So I'm happy to do it. And it's also a mindset. I have the underdog mindset, right? I enjoy doing battle against superior forces. And that's that sort of mindset that I like. And you combine all of that. And when I was 14 years old, I thought I was going to be a pastor for a Lutheran church. I enjoyed working in the church, and I was given sermons at 15 years of age.
Wow.
And so, but I get to do that role now in front of a jury.
Yeah.
Because an opening argument or a closing argument, just like a sermon, just like a homily, right? You gotta, it's got a start, a middle, and a finish.
I never thought of it that way.
Absolutely. So when I'm on trial, and I get an alter ego comes out, and I get to be a person that I'm normally not, and I enjoy it very much.
Wow. Well, I came to start following you more during the Aaron Thomas case, which recently came to a conclusion. Could you tell us a little bit about that case and the difficulty? Just from my uneducated point of view, I thought it was going to be almost impossible for you to convince a jury that his actions were not for sexual gratification purposes, and you were able to convince them that they weren't. And I thought that was a very fine line to walk, and you did it successfully.
Well, I didn't do it alone. I had the benefit of outstanding co-counsel with John Calcagney. And when I first got hired by Aaron, my first phone call was to John that this was a case. This was going to be a two-person case.
Yep.
And John came on board. Thank goodness. That is a case. I think it's a classic example of salacious charges, a media onslaught.
Yes.
Right. And bad optics. Right. And they all combined. And here you have on one side this incredibly accomplished coach and teacher with 3 decades under his belt. He personally built the best public school, high school basketball boys program in the state. They competed year in, year out for championships. And this is a small town in, North Kingstown with great methods in terms of teaching kids the right way to practice, the right way to train, the right way to eat. And the testing program, which got labeled fat testing. Fat testing was one component of it.
Yep.
It was really body composition testing was a big part of the success of the program because Aaron wanted to make sure that his student athletes were in the best shape of anyone on the court. And in the waning minutes of the fourth quarter or overtime, his kids were not going to lose steam. We had to convince, John and I, the jury, that the testing program itself was legitimate. It was based upon scientific and physiological principles at the time. It was administered in a non-sexual manner.
Right.
And the intent was to make the student athlete better. And that was, we knew from the beginning, an uphill battle.
Yeah.
When you've got bad optics.
Right.
And the bad optics here were a teacher alone with students in his office in various stages of undress, right? The shy or not shy question was posed. Aaron took the stand for 4 days and did, and indicated all of this. And students were allowed to take off, their underwear to test the inner thigh portion. Should it have happened? No, of course not. Aaron shouldn't have been alone with the students. They certainly shouldn't have had to take off any of their undergarments per se. And he admitted that on the stand. But he is sort of that old school, and I compared him in my opening argument to Bill Belichick. He just had one way of doing it. This program started in the 90s where, community standards of coaches being with naked students is not what it is today,
Right.
30 years later.
I remember being in the showers, baseball teams, 30 guys, coaches coming in and out. Now it just seems like that would not be acceptable.
Yeah, when we went to high school, there was a bullpen style showers.
Correct.
You'd never see that today.
Right.
Now it's stalls.
Right.
Cumberland Middle School, the shower area, I have it on good knowledge, came with a window that the gym teacher could look into.
Right.
And monitor what was going
fighting.
on. Right? And then we had to make strategic decisions. Do we keep the case in Washington County or move for a change of venue? Because the publicity was such that it was at such a frenzy level and had made such an impact on North Kingstown residents.
Big time.
And they are part of Washington County. So that strategic decision, ultimately, we didn't move to change venue. We stayed right there. Sometimes it's better to be judged by your neighbors than strangers.
How do you make that evaluation? How do you come up to that?
Well, you ask yourself, who's our judge in Washington County? And that was Judge Melanie Thunberg. And who's going to be our judge elsewhere? Because we had no idea if it was granted, where would they send it? Judge Thunberg, who just retired, this was her last case, was universally considered a phenomenally fair jurist, fair to both sides. So we were fully prepared to take our chances in Washington County with a very fair judge in Judge Thunberg, as opposed to the uncertainty of going to another county and what judge we would get and what venue, what jury pool we would get.
So you wouldn't get any say in that? It's just essentially assigned, and would it be in
That's
Rhode
right.
Island, or would
It would be in Rhode Island.
So you
but-
could be up in Providence, for example.
Correct.
And what's the difference between a jury in Providence and Washington County? Does that weigh into your decision?
It does. Typically speaking, you like to see a jury judge a case where it's the same county, right?
Gotcha.
Because we're going to be talking about things that you want the jurors to relate to. And it's easier for a juror in Charlestown or South Kingston to relate to.
Gotcha.
This is the North Kingston basketball
Oh
program.
yeah, I know him. Right? My son went there.
Exactly.
Gotcha.
Exactly. So those were the initial strategic decisions. And then it was the second strategic decision was, should Aaron testify? Well, that was an early one. Easy one, should I say. He had to explain how the program started, how it developed, what the testing meant, why it was conducted in the manner it was conducted, and did it work? So from the beginning we committed to the fact that he would have to testify.
Yep.
In most criminal defense cases, a defendant does not testify.
Right.
For obvious reasons. One, the burden's on the state to prove the case. And sometimes a defendant does themselves no favors
Right.
taking the stand.
Makes sense.
And all the good work you've done on cross-examination goes by the wayside.
Right.
Aaron turned out to be a phenomenal witness. First of all, he taught us what the program was all about, how it started, how it developed, what the scores meant, and what the testing protocols were, what the goals were, and how it helped his students get better. He was on the stand for 4 days. He underwent 2 days on direct and 2 days essentially on cross-examination. And that was absolutely essential to get that message across. And the third strategic decision we made was, do we request a lesser included? The charge was second-degree child molestation, because that allegation dated back to where the student allegedly was under 13 years of age. And the second charge, the second student, was second-degree sex assault. That student was a minor, but not under 14.
Gotcha.
The lesser included of both of those is battery, misdemeanor battery. Meaning that if the jury found that the touching didn't rise to the level of sexual gratification, but was offensive in nature, they would have an out. Now, the statute of limitations had run on count one, the second-degree child molestation, because the statute of limitations on a misdemeanor is 3 years. It had not run on count two. So for us to get the lesser included on the child molestation, we would have had to waive the statute of limitations. And we did so readily, knowing that when jurors go back there, and I talk to a juror in every case I do for the last 30 years, I know when they're back there deliberating, there's a lot of back and forth, there's a lot of compromise. And in this case, we felt, John and I, that the jury needed an alternative. If they weren't at sexual gratification beyond a reasonable doubt, they weren't necessarily going to give Aaron Thomas a pass.
Right.
And the battery is exactly where they landed.
Wow. And that came with, was it probation or like?
Yep, the maximum, nope, yeah, correct. The maximum penalty on misdemeanor battery is 1 year in jail. The state requested 2 years to serve.
Yep.
A year of on each count consecutive.
Oh, okay.
And Judge Thunberg, in only how she can do it, made it clear that it wasn't worth more than a year probation. And that's what she gave, a year probation.
Wow.
All right, consistent with being a first offender.
Yep.
With, lots of, rehabilitation.
Yep.
And quite frankly, we told the judge what Aaron Thomas was convicted of was exactly what we offered the state before a trial. Before a 6-week ordeal took place. The complaining witnesses, through their counsel, they were on board with misdemeanor amendments as well to avoid a trial. Their issue is more with the supervision or lack of supervision by North Kingstown.
Gotcha.
As opposed to whether or not it's a misdemeanor assault or a sexual assault. Ultimately, the Attorney General's office made the decision to go forward on the original charges for their own reasons,
Yep.
which we respect. And that's what the trial process is all about.
Interesting. You mentioned the school, the district, like you're seeing in Smithfield right now with the hazing going on there. It's crazy to see how quickly a small town and a very formal but informal body in the school department can quickly be on the hot seat for something, and the pressure and the intensity of it. So I feel like North Kingston, Smithfield, all of a sudden get thrust into this regional spotlight, and I don't think a lot of those folks are prepared for that or sign up for that.
For sure. I've been following Smithfield closely because, I raised our kids in Smithfield.
Gotcha.
They didn't go to the high school, but they went to the elementary school, the middle school. It is a wonderful community.
Yep.
It is a great community to raise your kids in. I live in Coventry now, and I miss Smithfield very much. And there will be, already you saw in today's news that the top school administrator is placed on leave.
Yep.
For decisions that she made or didn't make. And in the Aaron Thomas case, the superintendent ended up getting fired by the council. The assistant superintendent had to leave as well. There were huge ramifications, unfortunately. And these are career people dedicated to the students, et cetera. Right. As the criminal defense attorney with Smithfield, I'm not one to rush to judgment, right? And things should be investigated, et cetera. But there's the other component of, and that's that the yin and the yang, the tug of war between what sanctions should be imposed before we even know what's going on, suspensions, et cetera, and the optics of is the administration taking it seriously?
Right. Switch gears a little bit. Do you do post-conviction relief?
I do.
Can you tell us about that? That seems a little bit lesser known, at least to me, and not talked about too much. What is post-conviction relief?
So post-conviction is motion practice and work after the conviction, post, where you're trying to vacate either a plea of guilty or nolo contendere, and a sentence to work toward a bigger purpose. And I'll give you an example. When I started in private practice, John LaRochelle gave me sage advice. Mac, pick a second area,
Gotcha.
Besides just criminal.
Gotcha.
And for me, immigration work made sense. I was interested in it, deportation defense, so I started to do it. And it's out of the Boston immigration work. And what I found was it was so difficult winning a client's case unless I was able to vacate the criminal conviction that was at the heart of deportation.
Gotcha.
The heart of the removal case, they call it. And so I focused on post-conviction, learning how do I vacate a plea? There's three ways to do it. Either the judge made a mistake, or the prosecutor made a mistake, or the attorney for your client made a mistake. So I learned to focus in on those three areas, and really vacating pleas. It's very difficult to vacate a trial finding, right? Witnesses testify, judges or juries dictate credibility, evaluate credibility. But I focused on vacating pleas, and I learned that this is a heck of a lot better than traveling to Boston for 3 hours on the Southeast Expressway for a 10-minute hearing.
Right.
So I got away from deportation defense. I still do green cards and citizenships, but all of that, I do more post-conviction now. And since I've started in 2001, I have vacated approximately 500 cases.
Wow.
Right, 500 cases from mostly state of Rhode Island, some Mass, very difficult federal court to vacate a plea. But at the state level, I find that prosecutors and judges are sympathetic to real immigration consequences.
Gotcha.
That someone that pled to a vandalism charge in 1995 really had no idea that that could be used to deport them 25 years later.
Gotcha.
And so that's the sort of work I do. I do a lot of it. I work in conjunction with other immigration attorneys let's say someone wants to become a citizen, the first thing I'll do for the client or for their attorney is review their criminal history. Are there any convictions here that will prevent citizenship, or are there convictions that will put them into removal proceedings?
Got you.
Because that happens.
Get you in the
Right? Where not only are we denying citizenship, we're going to try
yeah.
to deport you now.
go.
And so I make that a specialty in terms of doing that, and I find it very fulfilling.
What do you think about the way that deportations are happening today with the current administration?
I think it's an absolute disgrace, right?
What's happening now? Like, could you boil it down simply what they're doing with deportations versus what they did historically or what other presidents did?
Exactly. So the rules on the books haven't changed since 1996.
Okay.
In reality, they haven't. The Illegal Immigration Reform Act, which was passed under the Clinton administration, is the general broad parameters of the rules. Okay? What can get you deported? What can get you excluded? What can deny you citizenship? What can deny you even getting a green card, etc. And it's the last time our Congress and president were able to compromise on immigration, because it's been such a hotbed issue. In other administrations, the priority, there's only so much money, there's only so much prison space, detention space. The priority has always been focusing on criminal deportees. Folks that either have a green card or are deportable because of a criminal offense, folks that are here illegally but have a criminal record. And I saw that for years. Now I see this administration is focused on enforcing the law, but doing so in a way that is detaining unnecessarily far too many people. Because the whole idea of bail, detention is completely up to ICE. So you get swept off the street and the ICE official says no bail for you. That is probably your fate for the rest of the case. All right? And an immigration judge is rare. It's rare that that is overruled. So you have so many people now that they may have been ordered removed years ago. They may have been fully complying with an order of supervision. But when they show up again for a review, they're getting detained. And they may not even be removed, but it's just the detention numbers. The administration wants to drive their policy of 1 million deportees. And it's unrealistic, it's inhumane, and it's counterproductive. Our economy is so dependent upon workers who happen to not have status in this country but are willing to do the jobs that Americans aren't willing to do. And we'll see it. We've seen it in the short term. We'll see it in the long term in terms of economic productivity, visitation to the United States, travel. All of that will be hurt. It is one thing to enforce the law. It is another thing to have a policy-driven agenda where you're locking up so many individuals unnecessarily. And getting swept up in some of these rates are U.S. citizens or permanent residents as well. We're all about secure borders. It's all a question of how secure. How do we enforce it? How do we make sure they're secure? How do we do it? The administration has picked a path that I think the vast majority, or at least the majority of Americans disagree with. When I see the polling numbers, Americans, by and large, don't want to see, ICE officials out there with their faces covered, with their identity covered. It is just something that as Americans we're not used to, and we don't generally like. Now, a core constituency of the Trump administration will always love that, but we'll see with elections, et cetera, in 26 and 28 if that will continue.
How about the amount of people that are self-deporting? It seems like that number is like 2 or 3 times more than what we've actually manually deported. So do you think part of this is also to scare or to make people do it on their own so they don't have to go through those types of experiences?
There's no question. You've heard the saying, the cruelty is the point, okay? And it sends a message. Border crossings are at an all-time low, okay, because people don't want to risk coming here knowing full well they're going to be detained or turned around, etc. The asylum policies of past administrations are on halt right now. It is very difficult. In the past, for instance, you could cross the border, request asylum, you would be processed, you'd be given a court date, but you would be allowed entry in. And those days are over. And that has had, the effect of certainly border crossings, etc. And now you have individuals that understand that they're one bad day away from getting caught and detained. And when you're detained by ICE, nothing's quick. It may be 3, 4, 5 months before they put you on a plane to send you back to your home country. And with certain deportees ending up in third world countries, different from their own, right? You're from Guatemala, but you get sent back to Africa, okay? That is happening now with the whole effect of you don't want to mess with the United States immigration system. So there, you can see how it's effective in terms of driving up self-deportees, driving down border crosses. The question is it the right policy for America? When Ronald Reagan, ultimately, his farewell speech in 1988, he called the United States a city on the hill and referenced the immigrants that were part of it. We are an immigrant country.
Yeah.
And
what are you, by the way? You Irish?
I'm Scottish.
Scottish? Okay.
Yep.
I'm Polish and Irish.
Okay, yep. I got some Irish there and I got some English, mostly Scottish. We're all immigrants.
Yeah.
And it's all a question of how do we balance? We need immigrants. This country of 330 million needs an immigrant base coming in and staying here, not only working jobs that Americans don't want to work, but the high-level, high-tech jobs, okay? The H-1B visas, for instance, the EB-5 investment visas. All of that's important. How do we do it in a way that balances the need for secure borders, enforcing the law, but allowing a population that contributes far more to the productivity of our country than it takes away? Right? I mean, on balance, it's not even close. What immigrants of all types, those who are here without status, those who are here as permanent residents, what they contribute en masse versus what they take away from the system, it's not even comparable. All right? And that is what people don't see. It's easy to jump on the message, illegal, get rid of them. Not so fast, okay? I often ask the question for those people, how did your ancestors get here, by the way?
Everybody.
Right? What's your background? I didn't notice the Native American last name, okay? So we all got here somehow, some way.
That's right.
Right? And it's about balancing that. So I'll work with a lot of dreamers, okay? Folks that came here as minors who didn't have a say crossing the border and have been here 10, 15, 20 years. What do we do about them, right? Under the Obama administration, a policy started to allow dreamers to get some sort of status. So they get a driver's license, so they can go to college.
So they can plug in.
Yeah, exactly. So they get a social security number. All of that important, knowing full well it's not their fault they crossed the border at 7 years old or 7 days old.
They didn't even know.
Right? But it's a policy that can't get through Congress because, in my opinion, the opposition party, whoever it was at the time, has no incentive to compromise on an issue. They'd rather have the issue. And that's been both sides. But particularly the Republican side has refused to budge when it comes to an 80-20 issue. 80% of Americans are in favor of dreamers getting citizenship status. Under the Trump administration, unfortunately, the program doesn't accept any newcomers now. It's essentially shut down. If you had deferred action before, you can renew it, but no new pool of applicants.
Gotcha. What do you think about birthright citizenship?
I think the 14th Amendment speaks for itself, and if you're born in the United States, you are a U.S. citizen. And I don't think there's any way of getting around that. You can make spacious legal arguments to the contrary, but in my opinion, the 14th Amendment is clear as day. Just like the amendment barring a third term by a president is clear as day.
Yeah, that's going to be challenged, I feel.
We'll see. I mean, President Trump has indicated that he does not wish to pursue a third term. I don't think he does either. It's it's a lot of talk.
Yeah.
And I think a lot of that is all about him trying to avoid being, a lame duck president.
Yeah.
Knowing that other people are running.
Yes.
President Trump enjoys the limelight.
100%. 100%. Last thing here, and then we'll wrap up. I know you're a busy guy. Is Providence's mayoral election is going to be coming up next year, and you have Mayor Smiley, who's the incumbent, and now we have David Morales, who is going to be challenging him. David is an advocate for rent control and rent stabilization in the city. Do you have an opinion on that, on rent stabilization?
None whatsoever.
None.
I stay in my lane.
Gotcha. Well, I'm a landlord, and obviously we're a real estate channel, and something like that is scary to us, that the government could tell us how much we could charge, but doesn't control any of our expenses. So that's something that is going to be, I think, national news when that election comes around, depending on the outcome. But to me, it's scary from an investment standpoint that your livelihood could be dictated by government, in that regard.
Understood. Yeah, we saw that in the New York City mayoral race.
Yep.
Where Zohan Mandani, who has this even more than progressive approach.
Correct.
Outright socialist in terms of some of the actions he's advocating. He advocates. The assembly has to, they have to pass it ultimately. But voters these days are so focused on affordability. I mean, Trump is president now because the inflation rate under Biden was far higher than people would tolerate.
Yeah.
And it's easy then for people to remember the strong Trump economy pre-COVID, and the promises that he made on the campaign trail. Same thing at the city level. I mean, I am a tenant of the Turk's Head building, but we pay the taxes ultimately that the city of Providence levies. We pay a tangible property tax, which I still don't understand, but I pay it every year because ultimately I want the city to be able to afford the services to make it safe, secure, clean, and I think they do that at a very high level. I have worked in Providence for the last 30 years, and I love working in Providence. It is a great city to work in for. If I were a homeowner or a residential commercial owner, I would be scared to death of bureaucrats making decisions about how much I can charge.
And a lot of them, John, are tenants.
Yeah.
Which we've seen at the State House with a lot of that legislation. That's right. Many of them are tenants, and they're making legislation against landlords having never been in that position. So it's like, it's a scary thing. It's a scary place. But Rhode Island, I love. And I'm a big fan of Woonsocket. I'm a big Woonsocket guy.
We pronounce it Woonsocket.
Woonsocket. I love it, and I think there's a lot of money on the ground in Rhode Island. You just have to really want to work. And I'm very grateful to this state.
Well, it's been a pleasure. Are you a Woonsocket native?
No, I'm from Connecticut.
All right. But in Woonsocket, we would say side by each, as we were. Pleasure, Greg. Thank you for having me
much.
On your show.
And if anybody has any questions, how do they get in touch with you?
Best way is to go onto my website, aggressivelegalservices.com.
Ooh, good name.
And you can shoot me an email, and I'll get it right away.
Cool. And if you have any questions for me, comment field below. We'll get right back to you. Once again, Greg Rice and John MacDonald here at the Turk's Head Building in Providence. Thank you.